14 years ago, almost to the day, the then Premier of Bermuda, Dame Jennifer Smith, addressed the House legislature in the following way. Let me begin by saying only 2 weeks ago, I reiterated the policies that underpin this government. Mr. Speaker, I know that you are well aware that many contractors and suppliers have benefited from this government's policy of providing a level playing field of opportunity for those who have never before received government contracts. I could consider that the opposition were merely being mischievous or hypocritical when they suggested that they, in spite of a well-earned reputation based on past actions, would, if given another chance, reverse their previous policies and open up the bidding process. For generations, successive United Bermuda Party governments systematically excluded the vast majority of Bermudians from participation in mainstream economic activity in Bermuda. This is a fact. It is not something to get excited about, but it must be acknowledged. To redress the pernicious practices that were the norm prior to November of 1998, practices which created the conditions that effectively precluded all but those with ready access to significant capital and lines of credit. The government has worked to remove such barriers over the past 4 years. The government's records are replete with examples of cost overruns which Bermudians have been burdened as a result of the ineptitude of the contracts awarded, not by us, but by the now self-righteous and forgetful members of the previous administration. Our policy has been to broaden opportunities and participation, and to ensure that those who have previously been excluded are included. What she meant by that was that in her view, the majority of black people in Bermuda have been systematically discriminated against in the awarding of government contracts by the previously elected administration. It was believed by some that the mandarins of the civil service were complicit in that discrimination. Not all, but some. It is no part of my task to seek to persuade you, the Commission, whether this is true or not. What cannot be denied, bearing in mind when that speech was made, is that it was the belief of many of the PLP and black Bermudians in this country that that is what was happening. Although your mandate was to look at the Auditor General's report for the years 2010 to 12, you've declared that you're going to look at a much wider picture. Your inquiry now dates back to as much as 2001 and as forward as much as 2016. The attempt, as it has been characterised by some in the press, if not elsewhere, to include the airport in 2016 looks like an attempt to do something that's not PLP-led. Again, it's not part of my responsibility to seek to try and persuade you one way or the other. What you will appreciate, though, is that you're not operating in a vacuum, a word I think you used to me some time ago. The reality here is that you are operating in a country, in Bermuda. Your colleagues, they know Bermuda. 2 of them are Bermudian. People know each other in such a small place. They know each other well. They're related by birth or marriage. They're neighbours or colleagues. They go to the same church. They support the same charities. They eat in the same restaurants and drink in the same bars. This is particularly true of black Bermudians, especially the older generation. I hope you'll forgive me for saying so. The reality is this: they greet each other in the street. They say, "Hi, brother." They refer to each other as uncle or father. This is cultural. This is part of being Bermudian. It's something I recognise as a black man arriving in this country a few years ago. People greeted me in that way that I had not experienced for a long time. There is a fidelity and a kinship between black Bermudians that is different to their white counterparts. It's just different. What does all this mean? It means, doesn't it, that the PLP and its mostly black elected representatives wanted to help their people. It was the mandate upon which they were elected. It is the basis upon which they were there. It has nothing to do with corruption or backhanders. It's got nothing to do with kickbacks or commissions. It's got everything to do with redressing the balance as they saw it, making sure that those who had been excluded for far too long were going to be included. And so what? And we had to bend the rule here or there in order to include them. It was allowing other people in this country to take advantage of contracts that the government had. Derek Burgess unashamedly asserted as much and was proud to do so in his inimitable style. In that endeavour, it was all too often the perception of some of the ministers that senior civil servants did all they could to thwart it. I say again, not all, but some. And it's no part, again, of my duty to seek to identify others, save to point out Mr. Brady, who I shall return to in due course. What you're likely to do, I suspect, having heard all of this evidence, is to come to the conclusion that there was indeed some circumventing of the rules in order to achieve, we would say, the stated aim of government. That is not to be equated with criminality, illegality, or any other serious wrongdoing. I'm not suggesting, and I make clear, that there wasn't on its face, on occasion, the breaching of some rules. But you will set that against that which we have submitted about the desire of a government to change the way things had been done.
You've mentioned Mr. Burgess in that context,
yes.
And as you say, he spelled it out very clearly in his submissions to
Yes.
us. And let me say, we can quite see how that is relevant to the contracts with which he was involved, or the ones he was talking about. But in due course, when you come to the Ambling and Global Hue contracts, where substantial sums were paid out of the jurisdiction, will you explain how what you've said is relevant to that?
Well, may I make it clear, first of all, that I shan't be dealing with those contracts because I have had no witness give evidence in relation to those contracts. It would not be for me to seek to try and draw inferences in the absence of any evidence in relation to my clients, so far as those contracts.
Well, let me just say this. On the face of it, the evidence we've heard shows that substantial payments, very substantial payments, were paid out of the jurisdiction. And I just wondered how the submission you just made could be relevant to those.
Well, I say again, it's not for me to seek to persuade you in the absence of any evidence dealing with those contracts specifically from any of the clients I represent. I'm seeking to try, if I may, to put into context some of the contracts, and certainly those, and I'm going to dwell on one in particular when I come to the evidence, to try and illustrate the points I'm making by referring to that one contract.
But you do represent, you're speaking on behalf of Dr. Brown.
I am, but I'm very conscious of the fact that he is not giving evidence. Had he given evidence in the circumstances, it would have been a very different picture. And of course, I would have dealt with, and I anticipate we'd have been here perhaps for a whole day while I dealt with each of the contracts.
Well, as I said yesterday, both in relation to Dr. Brown and Mr. Donald Smith, in the absence of any evidence from them, which might or might not have challenged evidence we've heard, we have no option but to proceed on the basis of the evidence we have heard.
Well, can I say that I am going to turn to the appropriate inferences that you might want to draw in due course. We make the point, though, that to ask, for example, Alan de Silva, in writing, whether he'd made any political contributions in the relevant period, ignores the fact that it is common knowledge that his brother was an MP, that he was party and supporting of his brother. To ask Messrs. Mappy and MacLeod whether they had made contributions to the party that they had won the contract from, when we know that the contributions they made came after the signing of the contract. And these are obviously questions designed to besmirch witnesses, potentially, as to what contributions they might have made in order to try and gain some contract. But reality here is that what does it mean beyond making a contribution. Many, and perhaps the more canny organisations in this country, contribute to both parties. Many do in other countries too. It's not an unusual phenomenon. The mere fact that someone has contributed, particularly on a small country like this, to a party, ought not to draw anything from that by way of an adverse influence. If people felt that they couldn't contribute to political parties for fear that they would never win a government contract ever again, I suspect there'd be an awful lot of companies not in a position where they were paying anything, and as a result, would the parties themselves would find themselves without any money. The reality here is that this is not an unusual phenomenon. Many people support one party, either by voting, activists, or as donors. And I suppose one of the things that you as commissioners might ask is, well, have I ever donated to a party or supported someone in a particular party? Does that in some way exclude you? The Premier's mandate states that he is calling for this Commission of Inquiry, as it is his opinion that it is for the public welfare. Now, you will understand that the Commission of Inquiry is seen by some as a continuing witch hunt, not for public welfare, but for the OBA's welfare. That is a fact that has been circulating that you will be aware of, and indeed has been said in this building. That its remit is both as to timing and substance is aimed at previous PLP administrations, Brown's in particular. So that at a time when the current government's unpopularity, it might be thought by some, is at its height, it is able to point to the alternative party and say, well, you can't trust them, can you? The mandate seeks to focus on 5 separate heads for your consideration as to what happens once you make your findings. The DPP for criminal conduct, the head of the civil service for disciplinary offences, the Minister of Finance for surcharging, Minister of Legal Affairs for civil asset recovery, and the Attorney General as to any civil proceedings that might be brought. This is all aimed at punishing the wrongdoers rather than seeking truth and reconciliation for the benefit of Bermuda as a whole. I'm aware, of course, that the mandate also asks you to look at safeguards, accountability and the reduction of risk for the future and to make recommendations in relation to that. But on its face, it's only after you've considered and reported the apparent wrongdoing. In your first public statement on the 13th of June, you said this. Turn to the issue which arises is whether it would assist the Commission's search for truth if witnesses had been granted some, albeit limited, forms of immunity in respect of their evidence and information, documents and witness statements provided to the Commission by them. The Commission has reached no conclusive view on either of these matters and proposes to defer in its decision until further investigation of the documentary material has been undertaken. No immunity, so tough luck, sink or swim. And I ask, and I do ask it rhetorically, not literally, why not? Why not give some limited immunity to those who are facing those 5 categories of everything from discipline, civil proceedings, criminal proceedings? Why not? Are you not likely to secure the best evidence by guaranteeing people will not be prosecuted for speaking the truth, or will not be reported to their civil service bosses for speaking the truth, or for fear of being surcharged?
I don't think we've ever been asked to consider that question of immunity or rule on it.
What?
And it's interesting that in another recent public inquiry, not in this territory but elsewhere, I understand there was a provision that nothing said in evidence would be used against the witness in question.
Yes.
Therefore, it is conspicuously absent from our terms of reference. But we've never been asked possibility was raised in what we said in the opening statement. We've never been asked to rule on that.
No, but if I may respectfully say so, it's not a question of whether someone is asking for immunity. It's a question which clearly you recognised was an issue. It's an issue which was of some importance, and I ask, and I do so, rhetorically as I say, why on earth not? Why did the Commission not consider that actually to get the best evidence from people, maybe providing some limited immunity was a good idea? I mean, if the truth of the matter is to try and seek, as was put by the Premier in calling such an inquiry, that it's for the public welfare, then actually truth is much better, isn't it, than simply seeking to try and punish people for getting it wrong, whatever their motivation might have been. And what I would seek to persuade you of is that perhaps as a result of not taking that step, that you may not have been told the whole truth, that you may have been given half-truths or even downright lies. Who knows? And the ability, of course, of my learned friends to cross-examine is, of course, to some extent limited in the forum that we're in. But the fact remains that providing no kind of immunity at all must, we would submit, inevitably limit the scope of potential witnesses. It stops, first of all, people even coming forward, does it not? They don't even volunteer to give evidence if they are fearful that if I said anything, it might be held against me, it might hold up my career in the future, it might affect my relationship with the people I'm working with, any number of issues of that kind. You didn't, for example, also consider, as you had the right so to do, whether or not evidence could be heard in camera. Had you combined those two powers, and that was one which was specifically mandated for, had you combined those powers, it may be that you would have had a greater honesty in some of the evidence that you've given. And ultimately, you're going to have to make a judgment about whether people have or have not been honest. And sometimes it's not simply a question of honesty, it's whether or not they've left things out, it's whether or not they've been reluctant to come forward and speak. As I say, I don't want to repeat myself. I'm sure, all
well, there, I think just to keep the record clear, in relation to evidence in camera, there were one or possibly more witnesses and we heard that there were suggestions that they might apply to have their evidence in camera. But I think I'm right in saying we were never called upon to rule on that.
Well, that may be so. I'm quite anxious that, and I know, sir, that you and your colleagues will understand, this is not in the nature of an adversarial process. You determine your own rules, you determine how you're going to gather evidence. It is a matter for you, in the first instance, to seek to set out the basis upon which you're going to get the best evidence in order to reach the conclusion that your mandate requires. And I simply placing on your shoulders the burden of having to make that decision. Clearly it's something you considered, and it's something which you left open. And I would simply make the observation that given the range of complaints that you're going to have to seek to make recommendations as to the series of wrongdoing and the various parties to whom you report, it seems, at least to us, that that was something that perhaps might have been given greater consideration and might have generated better evidence. And one can put it no higher than that. We simply do not know. But the power is there and exists, and it's there and exists for a reason. There are many who I've already said believe that this is a witch hunt in any event. What is it that fuels that belief? What is it that makes people feel that perhaps this is a witch hunt and are perhaps reluctant to come forward? Well, the appointment of 3 white members of the Commission of Inquiry with relatively junior black member, forgive me, Kumi, as opposed to the other way around, leaves them open to the suspicion of discrimination. The retired white British judge who knows little of black issues on this island, not a black judge familiar with Bermudian culture, that permits one to be able to say, you've never walked in my shoes, as one witness did. the ex-member and founder of the OBA, who was in opposition for many years that the Commission of Inquiry is interested in, leaving him open to accusations of bias as opposed to a non-political figure sitting in his shoes. The establishment of a set of white lawyers engaged to assist the Commission of Inquiry who were offered to provide legal assistance to any witness who wanted it, which had the bizarre quality of many of them finding it difficult to believe the same counsel would give advice, take a statement, examine them in chief, and then cross-examine them. And the apparent configuration of a tribunal set up to appear as if it is adversarial, when it is often the way that it is set up into a horseshoe shape and a rather more collegiate atmosphere created. And you, Chairman, stating in open session when Mr. Hargan opened this case all those weeks ago in respect of the Port Royal Golf Course, saying that what you had heard sounded like straightforward fraud, when you at that stage hadn't heard any live evidence. All of those features play into people's belief that perhaps this isn't as fair as it might be, and that it allows them to believe that this might be some sort of witch hunt. Again, it doesn't matter, in a sense, whether that is true or not. And I'm not suggesting, can I say?
That because I was going to say, so what?
I beg pardon?
I was about to say, so what? You tell us that people believe this, that, or the other.
Yes, the so what
is being couched in very offensive terms. You've gone a long way to making a political speech, quite unlike any legal submissions one would normally expect before a judicial inquiry. But I haven't stopped you.
So you misunderstand me.
So what?
No, well, I'm going to answer your so what, but you misunderstand me. I am simply seeking to try and make you alive to the fact that there are people who are, and have said as much. Almost everything I've said I've drawn from the evidence. It's not me saying it, and you should not think for a moment that this is me making some kind of political speech. I'm here temporarily. I'm not making a political speech. I'm seeking to persuade you that you cannot ignore these facts, that this is not, you're not operating in a vacuum, as I said already. People believe that. Taken that against the fact that you've not sought to invoke the rights that people may have had by way of some sort of limited immunity. These are reasons why people may be reluctant to come forward and speak what they know. You can't ignore them. It's not intended to be offensive, and you shouldn't take it as personal in any way. And I'm not suggesting, as I say straight away, that any of these things are true. Any of them are true. It's not the point, is it? The point is some people believe them to be so. All of that has led and fed into some people's belief that this is a witch hunt. And if your work here is to have credibility, you can't ignore it. Because it has to have credibility not just to who you report to the Premier, but to the country as a whole. So those are what I would seek to put as the background, the backdrop to which you are operating. And to seek to ignore them is to the detriment of the Commission's work.